I am Diana Santiago. I'm an attorney at Mass Advocates for Children, or MAC, which is a nonprofit advocacy organization with a mission of improving educational and life opportunities for children through education, legal assistance to individual families, and systemic advocacy. So at MAC, we have a project called Proyecto Acceso a la Educación Especial, which provides information and advocacy in the area of special education to Latino families specifically. So through Proyecto Acceso, we have a helpline for Spanish-speaking families to provide free of charge information, referrals, and advice in the areas of special education, school discipline, and bullying in schools. In very limited cases, we're able to provide direct legal advocacy to families through Proyecto Acceso. In addition to our helpline, we provide trainings to Latino parents on basic rights in special education and the importance of parent involvement, as well as transition in special education. So as direct service providers, if you're in a position to organize parents and you think that they would be interested in receiving a workshop, definitely reach out to me after the webinar and we can discuss that further. So I'm here with Lilia, a MAC Communications Associate, who will be receiving your questions throughout the webinar. I'm going to turn it over to Lilia for a second.
Hi, everyone. This is Lilia. Thank you for joining us. I just wanted to go over some technical things. You should see a menu bar on your screen that includes a question box. You can submit your questions there at any time throughout the webinar. I will read them to Diana during our question breaks that we have built in. We'll do our best to get to all of the questions. Depending on the volume of questions we receive, we may not be able to answer all of them today. If so, we'll let you know how to follow up after the webinar. You can also submit any technical issues through the question box as well. If you're having trouble hearing us, I can assist you with that. In the menu bar above the question box, you'll see we have provided 2 handouts. Feel free to download and print those. You'll also receive an email after the webinar with the handouts and a video recording and some other resources. Lastly, please fill out our survey at the end of the webinar. We value your input, and this feedback is important both for us and for our funders. Thank you.
Okay, thanks, Lilia. So before we start, I just wanted to talk a little bit about why we are doing this webinar, focusing on immigrant and limited English proficient, or LEP, parents and students. So since the last presidential campaign, and of course since Donald Trump became president, in addition to many already existing barriers, immigrant families have been and will continue to face very real threats as a result of increased immigration enforcement and the open anti-immigrant sentiment that we all see. One effect of these forces is to further inhibit parent participation in the special education process. So parents are simply less likely to participate in team meetings or interact with school districts and other government agencies. And we know that children whose parents participate access better services. So we see this as a priority to support them in any way that we can. And why are we doing this webinar for direct service providers? So often we get calls to our helpline from counselors, case managers, and social workers, many of whom are bilingual. And they're looking for advice related to their clients on special education matters. I've seen that many of you are strong advocates for your clients because of the knowledge and training that you have, and that you're also a great source of support as parents advocate to get the services that their children need. MAC staff can only go to team meetings in very limited cases, so we want to do what we can to support you all as direct service providers in the important advocacy that you do for parents and children. So this is an overview of the webinar, starting with some information about immigrant parent and student rights and recent changes. Then I'll talk about parents and the special education process in 3 main steps, starting with step 1, which are the evaluations, both school and independent evaluations. Step 2, the team meeting, and step 3, the individualized education program, or IEP, And then finally, I'll talk about when parents disagree with the school district still after going through all of these steps. Throughout the webinar, I will focus on the important role of parents for their children to access the services that they need. And I'll also highlight tools that parents who are limited English proficient can use to access services their children need. So I will stop for questions after each section, but please do send them in as they come to mind, and Lilia will be compiling the questions as we go. Also, we had said in the announcement that we would be showing some clips of our soon-to-be-released educational video series, which are 6 videos in English and in Spanish, highlighting rights that parents have in the special education process and tools they can use to advocate for their children. Unfortunately, due to some technical issues, you wouldn't be able to hear the videos. We're not going to be able to do that. There's some screenshots, but we definitely be looking out for these. We will be widely circulating them. They'll be available on our website, and hopefully you and the parents that you work with will find them to be a valuable tool. Okay, so the goals of this workshop or webinar are to learn how laws can protect immigrant and limited English proficient, or I'll just say LEP, children in the special education process, and to learn tools that immigrant and LEP parents can use to be part of the special education process and get the services that they need. Special education is a complex area of the law, and there's really no way that we can go through it in detail in one webinar. So for that reason, I'll say now, and I'll remind you throughout the webinar often, that MAC's helpline is a resource that's available to you if you have questions about a specific family that you're working with. Okay, so these are some legal protections that outline the rights of students with disabilities, immigrant students, and English learners in the arena of education. So almost everything I talk about during this webinar stems from these state and federal laws. Language access is a crucial component of all of these laws. I want to highlight very much that the right to a free and appropriate public education, or FAPE, applies to all students with disabilities who are eligible for special education services regardless of immigration status. And this stems from their right to a public education. And students with disabilities, many require special education services to be able to access a public education. So this stems from Title VI and also a Supreme Court decision that I'll be discussing briefly in a moment. And this is a screenshot of one of the educational videos that we have that focuses on immigrants and the special education process. Be looking out for. Okay, so these are just a little more on immigrant parent and student rights. The Supreme Court decided under Filer v. Doe in 1982 that all children have the right to attend public school regardless of their immigration status. And they actually use national origin is the determinant for or the way in which school districts are not permitted to discriminate against students. It's illegal for schools to discriminate against a student or a parent on the basis of national origin under the Civil Rights Act of 1964. So school districts cannot require students or parents to have a social security number or a U.S. birth certificate. And students have the right to be safe from bullying, harassment, or violence from other students, teachers, and school staff. In your handout is a flyer that MAC developed in collaboration with Mass Law Reform Institute that outlines the rights that immigrants have in education and also places where parents, agencies that parents can contact if their rights or their child's rights are being violated. So there have been some recent changes impacting immigrant and LEP students with disabilities in just the past year. So things move quickly. Um, I'll start with the good news, which is the Massachusetts Learning Opportunities for Our Kids Act, or the LOOK Act, which allows school districts flexibility to offer different instructional models for English learner students, for all students. So this is a shift from the English-only mindset and instruction for English learners. So since 2002, English language instruction has shifted towards because of the law to primarily using sheltered English immersion and which means very restricted use of native language instruction. So students with disabilities were exempt from the law. They were not technically impacted by the law, but they were definitely impacted by the shift to this English-only mentality and fewer options for instruction in languages other than English. So, for example, the number of bilingual educators dropped significantly after passage of the law in 2002. So we're hoping to see a change there. So similarly to the prior law, students with disabilities are not affected, technically or legally under the LOOK Act, but similarly, as disability advocates, we'll be looking out to ensure that students with disabilities have the same opportunities to benefit from opportunities created under the LOOK Act as students that do not have disabilities. So we'll also be looking out to encourage parents and children with disabilities who have children with disabilities that are English learners to participate in English Learner Parent Advisory Councils, or LPACs, which school districts are required to form under the LOOK Act. So going to the not so good news, this past year, the federal government proposed a new rule, specifically the Department of Homeland Security, relating to public charge. So this is really another blow to low-income immigrant families, and it targets children and people with disabilities directly. So under the new proposed rule, immigration officials are required to heavily weigh age, which negatively impacts children and the elderly, and certain health conditions in making determinations about whether an individual is likely to become a public charge. So this, in turn, could reduce their chances of being eligible to remain permanently in the United States. This new proposed rule also expands the categories of benefits considered in these determinations to include Medicaid benefits and also some housing benefits. So it puts immigrant families in the position of choosing whether to access these crucial benefits that they need to meet their children's basic needs and potentially harming their chances of being able to gain permanent status or foregoing those benefits altogether. So MAC submitted comments opposing this new rule and also participated in a nationwide campaign to flood the Department of Homeland Security with comments opposing the rule so that the Department of Homeland Security will be loud and clear that people are care about this issue deeply, and also so that they will have to take the time to review the over 200,000 public comments that were submitted. So this is not in effect yet, and they're expected after they review the comments. There's a waiting period, and then there will likely be legal challenges also. But there is a potential for this new terrible rule to be implemented. impacting the population of families that we all work with. Another something to be looking out for is the 2020 census. In June, the Supreme Court will be deciding whether the question regarding citizenship status can be added to the 2020 census. Regardless of where the Supreme Court falls on that issue, the impact is already happening in terms of immigrant fear in reporting anything to government agencies. So the concern is that immigrant families will be undercounted in the census, and so that areas that have significant populations of immigrants will receive less, will be undercounted in the census. So as people who work directly with families, with immigrant families, you will likely be seeing information in your inboxes and through other means regarding educating immigrant families about the importance of responding to the census, and also what their rights are in and their protections in terms of their privacy rights and completing the census. So important to note that eligible students with disabilities have a right to special education, even with the above changes. So that remains unchanged, the right to a free and appropriate public education. Okay, so I shouldn't need to say this, but in special education and just of course in general, parents are important. Parents know their child best. No one is more invested in the child's well-being than their parent or their guardian. They also, from a practical standpoint, bring very important information to the special education team. They see firsthand their child's strengths and struggles over time. They also can report on their child's learning and development at home and in the community, which is a different, very different perspective from what the child's teachers and other service providers in schools see. And it isn't just me saying this. The law also requires that schools give parents advance notice of all team meetings and give consent before doing evaluations and implementing the IEP. So unfortunately, as many of you may see firsthand, the reality is that it doesn't always play out in practice, and that children whose parents are involved in the process and fight for what they need tend to be prioritized by school districts in the special education process. And here in the slider outlined rights that LEP students, LEP parents have in addition as part of the special education process. And to continue highlighting that, when a parent's primary language is not English, school districts are required to provide qualified interpreters at all team meetings. And by qualified, it's not just about having someone that is bilingual there to interpret. The person interpreting should have training in the role of the interpreter, the ethics of interpreting, confidentiality, and knowledge of the specialized terminology that's used in that setting. So interpretation and translation is the first step to understanding what's going on at team meetings and the services that that children are receiving. In addition, all IEPs, evaluations, and school notices must be in the parent's primary language, in addition to being in English. And nothing in the law provides school districts with additional time to provide those translated documents. So they should be provided to the parents within the same timeline as the English document. And in terms of what to do if a parent is denied language access, parents have the option, if it's in the middle of a team meeting, they have the option to ask that the team meeting be rescheduled. That's always in the moment an option that parents have that they may not realize. And they or you on their behalf could also file a complaint with the State Department of Education Problem Resolution System, or PRS. And I've included the website here. The form is available in many languages. If you or a parent is thinking of filing a complaint with PRS, it isn't a process that requires a lawyer, but I would recommend that you give a call to the helpline, and we can provide you with some guidance on how to complete the complaint, so that they're really able to see the issue. We also have some templates that may be useful. So I'm going to stop here, see if there are any questions.
So we've had a few more people join us, so I just want to say welcome, and I'll go do a recap of some of our logistical things. We're going to be pausing throughout the webinar with these question breaks. You can submit your questions in the menu box on your screen, and I'll be reading those to Deanna during the question break. So it looks like we don't have any questions now, but feel free to submit those at any point, and we'll have some more question breaks.
Okay, thanks. Okay, so here we have the special education process and timeline, divided into 3 steps. Beginning with the first step, which is the referral for an evaluation. The second step, which is the team meeting, and the third step, which is the parent receives the IEP from the school district and responds to the IEP. So after a child is found eligible for special education, the school district should initiate evaluations automatically every 3 years. The team meeting to discuss the student's educational progress and services should happen at least once every school year, unless there's a reason for it to happen, which there often is, to happen more than once in the school year. And the timelines included on this chart are a really important tool for parents. They ensure that school districts respond without delay when a referral is made, and a child may need services. So it's really important for timelines to be effective as kind of an enforcement mechanism. It is important that parents keep copies, dated copies of anything that they provide to the school district, and that they always note conversations that they have with the school district regarding any aspect of the special education process. So throughout this webinar, I'll break down each of these 3 steps. Okay, so the first step, the evaluation. The important thing to keep in mind in terms of a referral is that anyone who has knowledge of the student can make the referral for special education. And this can be a family, it can be a parent. Oftentimes it can be it's an early intervention service provider to ensure a smooth transition out of early intervention into special education. But it can be, technically, it could be, a neighbor, it could be an aunt, it could be anyone who has knowledge of that student. Now, to proceed with the evaluation, of course, parent consent is required. So upon receiving the referral, the school, within 5 school days, is required a consent form. It's required to provide the parent with a consent form to proceed with the evaluation. And then within 30 school days from receiving the parent consent, they must complete the assessment. So these timelines are really important. And I should mention that as direct service providers, if you feel like it's appropriate to make a referral and the parent has some barrier to doing so, and for whatever reason you feel like that is something that the child needs, then you are also in a position to make a referral, knowing that it's always important to have communication with the parent, of course, about that. So there are a lot of types of evaluations, including the required assessments, um, the education, which are the educational assessments, assessments in all areas related to the child's disability, which can include a functional behavioral assessment or an observation or one of many other types of evaluations. For example, for students with autism, um, autism is a disability that often impacts um, student communication development, and so speech and language evaluation, or in AAC or assistive technology evaluation is often should be considered a required assessment. And if the school district doesn't propose doing an assessment in any given area, then the parent can ask for that. Also, psychological home or health assessment can be done at a parent's request, and transition and functional vocational assessments start at age 14. So functional behavioral assessments are often very important, where a student's behavior in the classroom is interfering with his or her ability to learn. Um, so if the child is, let's say, very distracted in the classroom, a functional behavioral assessment, somebody who's qualified to do that, or a team of people who is qualified to do the functional behavioral assessment can go in and observe the student and determine what may be happening before the behavior that may be triggering it, and then also make recommendations on how to address the behavior so that the student is able to focus and learn in class. Often we see if students are exhibiting behaviors that are causing the teacher to send them to the principal's office frequently. If that student isn't in the classroom, then they're not learning and they're missing out. And that's something that definitely requires attention, and the school district has a responsibility to further assess the student to find out what is causing that behavior that's resulting in the student being excluded from the classroom. So functional behavioral assessment is often something that should be recommended. Observation. Oftentimes parents call our helpline and they're concerned that the school district is not implementing the IEP, for example. And observation is really the best way to find out what is going on in the classroom or what is not happening in the classroom. It can be really hard to understand. Oftentimes, I'll just give an example. I had a student who used a tablet, an AAC device for communication that she required, and there had been multiple independent evaluations outlining recommendations for how to best support this student in using her AAC device. And the parent had concerns because she didn't see progress. And so during the team meeting, we would broach this with them, and they would assure us that they were following the recommendations. Well, we had an expert go into the classroom and observe that student, and it turns out that the device was not even programmed appropriately according to the recommendations. So just as a tool, the equipment, the basic physical equipment was not programmed in a way that was going to support this student. So on a very basic level, they were not implementing those recommendations, and it really required that observation to be able to raise the issue with the team in a way that was effective to seek ongoing consultation services for the students. As direct service providers, I often recommend that if you have the ability to do this, to go in and observe the students, especially people who have knowledge of the school outside of the school setting, you can provide a really valuable perspective there. Even just documenting what you see and what you don't see. Um, that can be really useful because it's difficult for the team to refute that information. So in that sense, you, the observation can be a really important tool for parents and for people that are supporting parents to advocate for services that the students need. School districts have to allow an observation, of course, with reasonable notice, and they are allowed to lay out certain parameters, but it has to be reasonable. So if there's the parent is facing a barrier to either observing themselves, their student in their child in the classroom, or arranging an observation, and definitely have them contact the helpline. And it's one of these things that's just so clear cut. Often a phone call, to the special ed director or the school principal is enough to resolve it. So another point related to evaluations, all special education evaluations must be in the child's native language or the form most likely to yield accurate information about what the child knows and can do. So this may require the school district contracting with someone if the student requires a bilingual speech evaluation or a bilingual any kind of evaluation. And the school district does not have the resources in district, then they may be required to contract with someone outside of the district to do that assessment. It needs to happen within the same timeline also that we talked about earlier in terms of the 30 days from receiving parent consent. So lack of availability of providers is not a reason to delay that process. So a little bit more on evaluations than English learners. So testing must be in the form, again, most likely to yield accurate information about what the child knows and can do academically, developmentally, and functionally. Testing must be administered in a non-discriminatory manner. So this often goes to the type of questions that are asked during the assessment. Cannot discriminate based on a student's national origin or their or for cultural reasons. All students identified as English learners also must be tested yearly for English proficiency, apart from testing based on disability. And so in an IEP or in the school record, you might see reference to an ELD level, which is English language development level, measuring English proficiency. And it's complicated in relation to students with disabilities, especially those that have limited verbal ability, teasing out, whether that score is meaningful or not, needs to be looked at kind of a case-by-case basis. Evaluation reports must be provided in parents' primary language. So as all other special education documents, these reports, it's really crucial for parents to understand the evaluations because they form the basis of the services and the placement for their child. And very often, maybe because it's not a kind of templated form, the evaluation reports, and they can be complex, school districts often do not translate these reports, but it is required that they do so. And so parents can make that request if they need to, but it's not legally required that they make the request. It should automatically happen. Okay, so the parent has, or the student has gone through the evaluation process. There's been a referral. The parent has signed the consent form. The school district did their evaluation and completed it. And there's been a team meeting to talk about the evaluation, and the parent doesn't agree with the school evaluation. Sometimes it can be that they actually disagree with what the findings and recommendations of the evaluator. They don't think that the recommendations are useful or necessary for their child. Sometimes it's just too vague to be useful at all as a tool to determine what that student needs to learn. So the option that a parent has, which is a very valuable tool, is to request an independent evaluation. And there are two different paths through which parents can request an independent evaluation. In the first, the school district pays for the evaluation cost using a sliding fee scale. So this can be for very low income families. If the student is eligible for free or reduced lunch, then the school district must pay. They can't require verification of income. Of course, the family annual income and sources must remain confidential. And so, the parent can request that the school district not, if they are showing documentation of income, they can ask that the school district even not keep that information on file after they show it to them. Under the second option, if the parent chooses not to provide their financial information to the school district, they request the independent evaluation, and within 5 days, the school district must either agree to pay for the evaluation or initiate a hearing with the Bureau of Special Education Appeals. So once there are a few things about independent evaluation, a few caveats. One is that if a parent is using this route, requesting that the school district fund the independent evaluation, they need to find an evaluator that will accept the rate that under state regulations school districts are required to pay for the evaluation, which is less than the private pay or most insurance rates. So that's one thing. And if you have a parent who's low income and is thinking that, maybe their insurance will not pay for the evaluation, and this seems like the best route to have it done, then definitely contact the helpline or have them contact the helpline. We have, evaluators who accept the state rate for evaluation. And also just to have in mind that the parent can arrange for an independent evaluation paid by their private insurance, or some evaluators do accept mass help. And if they do that, then the school district won't see the evaluation unless they show it to them, which for some parents that's very important, understandably. They kind of want to be able to see what the findings and recommendations are before showing it to the school district. So once the report from the independent evaluation is complete, and the parent shows it to the school district, or the evaluator has sent it to the school district, the school must schedule a team meeting within 10 days to discuss the findings and recommendations, and if necessary, make any changes to the student's IEP based on those recommendations. So Matt's website has sample letters requesting independent evaluation in English and in Spanish, if that's useful for you. And also, as I mentioned, if you're looking for independent evaluators that take rate setting rates, you can contact our helpline and we can provide you with that information. Okay, so that's a lot of information. I'm going to stop here to see if there are any questions.
All right, we have a few questions. I also just want to remind everyone that you can submit your questions through the question box on the menu box on your screen, and we'll be pausing throughout the webinar for questions. Okay, so our first question is, where can parents find professional evaluators for things like functional behavioral assessment in their native language?
That's a really good question. Oftentimes we get calls to our helpline for these for really specific evaluations or evaluations done in a specific way, as in a different language beyond besides English. And I would just suggest calling the helpline, and we can kind of work through it case by case because it's a problem. The lack of um, bilingual evaluators. Even in Spanish, I work primarily with Spanish-speaking families, and there there are very few evaluators, and that's, as we all know, a very common language spoken in Massachusetts. Um, so I would suggest if you contact the helpline, we can kind of talk through that on a case by case basis. It may involve, you know, me reaching out to um, other organizations that we collaborate with to get that information.
And our next question is, what is an example of a reasonable parameter a school can set for a parent requesting an observation?
A reasonable parameter. So the parent can't go in and observe every day, all day. I mean, that's probably a reasonable parameter. You know, in terms of the time limits, a lot of school districts, you know, even a full day, you know, could be, you know, depending, could be considered disruptive. They can't, of course, limit it to, you know, half an hour during, you know, the student's favorite class. Say math is their favorite class. You know, the school is not reasonable to limit the evaluation to that time, or to limit it to only academic times if there are concerns about the student's, um, you know, kind of transitions between classes, um, or social skills development, um, or even executive functioning skills if necessary to kind of see that student across different settings throughout the day. Um, but you know, so I would say in terms of parameters, you know, it's most often it's the amount of time um, that you know that is limited and can be considered reasonable. It's not completely clear cut. So
Thank you. And our next question is, can you request an interpreter if you use an English-speaking evaluator?
so there's an English speaking. I'm just going to take the question to be um, that the student had in was evaluated in English, um, and then the parent is requesting an interpreter. Absolutely, I think that's probably the most. I mean, it's the most common scenario. I know that I see just among callers to our helpline where the parent um, is limited English proficient, but the student speaks primarily English, so it's appropriate to evaluate the student in English. And absolutely, the parent can still request, um, can be entitled to interpretation and translation.
Thank you. And I know some of you are having some audio issues, so I'm trying to fix those. You can submit both your questions and any issues you're having with hearing through the question box.
Okay, so I'm going to go on, and hopefully my voice can keep up. If we need to take a short, like 1 minute break, if I have a coughing fit in the middle, that's probably the best way. We'll put it on mute for a minute, but hopefully that won't happen. Okay, so we've talked about step 1 of the special education process, which is the referral and the evaluation. Now we're going to talk about the team meeting, which, as I mentioned earlier, should happen at least 1 time a year, although there are a lot of situations where the team meeting needs to happen more than once during the school year. For example, if the parent rejects the IEP fully or in part, in their response, then the team needs to reconvene to discuss the rejected portions of the IEP. Similarly, if the parent has had an independent expert evaluation done within those, 10 days after receiving the evaluation, um, school needs to convene the team. Um, so that, but minimally, that should happen one time every year. The purpose of the team meeting is to talk about the evaluation, so school evaluations and independent evaluations that may have been done, and to decide if a child is eligible for special education, answering three principal questions, which are, does the student have a disability? Is the student unable to progress effectively in regular education due to the disability? Does the student require special education services? So those are key questions that need to be answered by the team. Um, Limited English proficiency must not be the determinant factor for the student requiring special education services. So the student should not be placed in special education because primarily because they're limited English proficient. Um, Similarly, students who require special education um, should not, or may require special education, should not have to wait to be evaluated while they're in a program for English learners. If there is an indication, if somebody suspects that that student has a disability, they should be evaluated right away in their primary language to determine whether they need special education services in addition to services as an English learner. Okay, the team meeting also, the purpose is to write the IEP, and also happens before a child's IEP ends for the period.
So if any of you have been to a team meeting, I suspect many of you have, you'll know that there are a lot of people that need to be there. And I'm not going to read through this entire list, but I will mention that, of course, the team includes the parent and includes the student also if the student is age 14 or older. And of course, a qualified interpreter must be provided if the parent prefers to have an interpreter at the team meeting. So it's a lot of people, and for parents, this can be really intimidating coming into this room, with 10 people around the table talking about their child. It can be very emotional. Sometimes things aren't going the way that the parent would want them to go, and it can be very tense. So as direct service providers, you probably see firsthand just how important of a support you can be at the team meeting, in perhaps raising issues that the parent hasn't raised because maybe they've forgotten to raise those issues. Even after the meeting, to kind of debrief, to talk about what happened, because oftentimes, there'll be kind of gaps in the parent's memory or anyone's memory because of all of the information that's being discussed. And then, of course, there are times where the interpreter wasn't effective in interpreting everything, so the parent hasn't captured all of the information. So, as direct service providers, I just want to emphasize, what an important role you play also here. So in terms of preparing for the team meeting, the parent can request evaluations before the meeting. So if they request this in writing, then by law, the school is required to provide the evaluations at least 2 days before the team meeting. So they can even write, when they're submitting the consent form, they can even write on the consent form that, please consider this my request to receive the evaluations at least 2 days in advance of the team meeting. Parents, of course, can invite an advocate, service provider, independent expert, or a friend to the team meeting. It can make such a difference for the parent to feel that they have someone there who's supporting them. and whether this person is a professional who has specialized knowledge or has a lot of experience going to team meetings, or even if if the parent doesn't have access to such a person, they can invite a neighbor, they can invite a sister, they can invite, anyone who they feel comfortable with, who's going to provide support during that meeting. Always, of course, suggest that the parent writes down parent concerns and questions in advance of the meeting. I always suggest that to helpline callers, because it's just too easy to forget everything walking into that room. I know I do it myself when I'm preparing for team meetings for children that aren't my children. So you can only imagine, when they're the parent, there's just so much information, so much they want to say, and it's easy to forget if it's not written down. And then the parent, I also suggest that if the access to a qualified interpreter has been a problem in the past, that the parent also, in advance of the meeting, address the issue. They shouldn't have to, because all interpreters should be qualified to interpret. But if they get the team meeting invitation, they see the attendance list, and they see that it's the same person there, the teacher aide who just knows kind of minimal English or minimal Spanish and is really doesn't know the terminology, or if it's somebody that they feel is biased and therefore not following rules related to ethics and confidentiality for interpreters, and the parent should address that up front in advance of the meeting. And hopefully the school district will arrange for a different interpreter. If it's a problem, have the parent contact the helpline, and we can talk through options there. So these are just suggestions. I know people have their own ways of preparing also. Oh, and I'll stop here to see if are there any questions, Lilia?
I'm gonna pause for a moment and see if anyone wants to submit questions now. Again, we're going to be pausing throughout the webinar to take your questions. You can submit them at any time, but I'll read them to Deanna during the break. Okay, looks like we don't have any questions, so we'll move on.
Okay, so now we've talked about step 1, which is the referral and evaluation for special education services. We've talked about step 2, which is the team meeting, and now we'll talk about the school district providing the parent with the copy of the IEP, which should happen within 45 school working days of the parent giving consent for the evaluations, and of course the parent's response to the IEP. So the IEP is a really important document. This is a legal document, and it's a contract that outlines the services that the student needs to make progress in school, and that the school district is required to provide. So many parents don't realize that necessarily, or maybe they just find the whole thing just too overwhelming. School districts also tend to encourage this. Sometimes I've seen cases where they just send the parent the signature pages of the IEP rather than the whole, which, we all know that that's wrong legally, very problematic to do that. So it's important that the parent have some understand the IEP, and take steps that they need to take to be able to really understand it. So I'm not going to have time to talk about each section of the IEP. If you would be more interested or interested in a more in-depth workshop on the IEP content, then definitely, if you could note that in the participant survey that you'll receive after this workshop. So for this webinar, I'm going to highlight opportunities that parents have to provide input on the IEP and addressing the learning needs of limited English proficient students through the IEP. So, whoops, I guess before I go there, I'm just going to talk a little bit about the parent concerns. So this is a section. This is a section of the IEP that's solely dedicated to documenting the parents' concerns in that moment in time about their child. Oftentimes, this can be the only place where those concerns are officially documented anywhere. So it's very important that the parent go into the meeting prepared to talk about their concerns. These can be academic concerns, social concerns regarding their child's social development, or their emotional development. It can really be anything that the parent is concerned about. And so, while indicating their concerns in this section doesn't necessarily mean that their child will automatically get the services that the parent feels that they need to address the concerns. This gives the school district notice, and it's documented that the parent has these specific worries, and it also can set the tone for the meeting so that the parent concerns ideally can be addressed during the team meeting. So, and there are a few examples of this where we often have parents who will contact our helpline or who are clients who have been advocating on their own for years and years before they've sought legal assistance. So we always request the student record, or we often do, not for every helpline call, but if it's a case that we're going to be directly involved in, we'll request the student record. And it's often surprising, even to the parent, to look back at prior IEPs to see when they first started noting the concerns that for which they're seeking legal assistance, 4 or 5 years down the road. So it can be a really useful tool just in having documented that student's development over time and what issues the parents have raised to the team. So I'm going to go on to IEP services. So this list is far from all-inclusive, which is why I added the last bullet. IEP services can include anything that the student needs to learn new skills and information and to make progress. So it's really limitless. The cost legally cannot be a factor in determining what services a student needs or availability of personnel to provide a given service. If the school district needs to contract with an outside agency or individual to provide a service, then they have to do that if the student needs it. So that's just important to keep in mind. And if during team meetings you're there and the school district is claiming that, we don't have a bilingual speech pathologist to do an evaluation or to provide speech services, bilingual speech services, so the student can't have it. It's important to document that. I would even follow up with them with an email, just saying, as discussed during the meeting, so and so said that the district cannot provide this service because of lack of availability of personnel, and just documenting that, and then it can be definitely grounds for filing a complaint, after definitely rejecting the elimination of that service or the absence of that service in the student's IEP. Okay, so this is probably familiar to many of you. This is a service delivery grid. And I think that I always include this because I think I know I find it to be a really useful tool when I'm reviewing a proposed IEP that the parent is considering their response to. And this is it's just a good summary of the type of services that the school district is required to provide for the student, how much of those students, how much of that service, how often they're required to provide the service, who is required to provide the service, and in what setting. So the top part of the service delivery grid is consultation, and this can be discussion about directly related to the student across team members or sometimes other specialists who aren't necessarily part of the team. So, for example, if the student, let's say the student is in inclusion, there could be a consult between the classroom teacher and an inclusion specialist. There can be, often a consult between the teacher and the home service provider. So those are services that the student does not access directly. And the middle part of this grid are services that the school is required to provide for the student in the general education classroom with non-disabled students. And then the last section, the bottom part, are the direct services that the school district is required to provide outside of the general education setting. So it's really helpful to compare from year to year when the parent has the proposed IEP, just to put the two service delivery grids next to each other to make sure that the student fully understands what services the student is receiving currently and any changes that are being proposed for the next school year. And when I talk a little bit about responding to the IEP, I'll again raise that the importance of doing that so that the parent can access certain rights that they have when the school district is proposing to make changes to the services. Okay, so the IEP and English learners, first and foremost, bilingualism is a strength, not a deficit, and the IEP should reflect this. I've asked for them to put it in student strengths and key evaluation results, which is a section of the IEP, for them to put right in there that this is a bilingual student and that as a strength. Oftentimes, even parents have internalized that their child being an English learner is that's a deficit that needs to be overcome. And this is often because direct service providers that they've had, have misconceptions about meeting the needs of English learners with disabilities. So I think it's very important to recognize it as a strength up front. The special education team must discuss the impact of language needs of the LEP student as related to FAPE. And the team must consider whether primary language instruction is necessary for the English learner student to receive FAPE. This can be a contentious point that often because of the challenges to the school district in sometimes accessing these types of services, the bilingual services, team members are often discouraged from agreeing to this, and oftentimes it requires a recommendation from an independent expert to support that student's need for primary language instruction in the classroom. But that is something that should absolutely be addressed by the team and included in the IEP. And finally, the school district must indicate specific needs and required instruction to address language needs throughout the IEP. I went to a training last summer on the IEP and English learners, and I liked how the facilitator of the workshop really emphasized that that students' needs as an English learner should really be infused throughout every section of the IEP. So I haven't seen an excellent IEP for an English learner student that I feel does that. But if any of you have seen that, definitely, I'd love to, if you could bring it to my attention. But it's definitely something to be alert to during the team process and also in helping the parent to respond to the IEP. Okay, just in time to give my voice a break. Are there any questions? Good.
Okay, so thank you for submitting your questions. We have a few more. The first question is, I guess, in reference to primary language instruction. Do you mean English language instruction or classroom instruction given in the child's primary language?
Yeah, good question. I was referring to the latter. So if the student requires language in their instruction in their primary language that is not English in the classroom, then if they need that in order to make progress in school, then the school district is required to provide it. Of course, that's a decision that's made by the special education team.
Okay, thank you. And our next question is, can you give an example of how a language need would be written into the IEP without conceiving of it as a limitation?
Now that's a good, I think, definitely having it up front there in the student's strengths is a way that it can, to kind of frame that, that student's needs as an English learner. I think that's crucially important. I think, in terms of the goals, with this, in terms of the Look Act, that I mentioned earlier in the workshop, I think that there are a lot of opportunities there to really highlight both for students who are English learners and students who speak English and are learning a second language in dual language classrooms. And I'm hoping that under Look there's going to be a shift more broadly, in terms of how people see bilingualism, could see bilingualism as a strength. So I think, that's the best example I have, is just literally having them list it as a strength, requesting that they list it as a strength in the IEP.
All right, thank you. That's it for questions for this break. I just want to remind everybody you can submit your questions at any time through the question box, and I'll be reading them to Deanna during the breaks.
Okay, thanks, Lilia. Okay, so there are, in terms of transition requirements, there are 2 key points in the special education process of student transition. One is when the student has been receiving early intervention services and is about to turn 3 and about to transition, so therefore about to transition into the special education system. The important thing here is that before the child's 3rd birthday, the district must provide the IEP and services if the child is eligible. So they must determine whether that child is eligible before the child's third birthday. So this means having received the referral, often from the early intervention provider, but it could be from the parent, having completed the evaluations that need to be done to determine eligibility, having had a team meeting, and having proposed an IEP for the student in time for the parent to review it and respond to the IEP before the child's third birthday, so they can start on that date to receive the services that they need. The second period of transition is when the student is turning 14. So this is called the period of transition in special education. And it's for students who are between the ages of 14 and 22. The start to the transition period are the transition assessments. That's really the first step of the process. And these should be formal and informal assessments. So it's okay to have some of the check mark boxed forms to determine that students' needs related to independent education, independent living, and work and higher education that fall within transition, but they should also include interviews with the student, possibly interviews with the parent, and interviews with others that have knowledge of the student, as those can often glean more useful information than the kind of check mark box assessments. The period of transition should include services at school and in the community. So especially for older students, it's not okay that a 19-year-old student remains, within the walls of the school all day without having any experiences in the community with support. These could be experiences at a work site, in an internship, with support. It could be participating in a program on a college campus with academic support and whatever other support they need to be successful if that student is thinking about pursuing college. So that's an important component of the period of transition. And also the student is invited to the team meeting starting at 14, which is something I mentioned earlier. So this is, 14-year-olds, they're still children. This can be touchy, for a lot of families. Understandably, sometimes the parent just doesn't think that it's going to benefit the student to be there listening to all of the information that's discussed at a team meeting, including a lot of areas of weakness and things that just aren't going well for the student, that it could be harmful to their self-confidence, to their self-esteem. Sometimes in those cases, I suggest that the student go for part of the team meeting if the parent is more comfortable with that. Maybe at the beginning to talk about what some of their concerns are, or maybe to give a brief presentation to the team about something they're working on that they feel is important, and then leave for the remainder of the meeting. So those options are available, and often many parents think that those are the most appropriate options. I have a parent. We had a team meeting a couple of weeks ago, and her daughter is 20 and has an intellectual disability. And when she was coming to the teen meetings and then asking her mother afterwards, what she had done wrong. She thought that she had done something wrong because she really couldn't understand everything that was going on, or a lot of what was going on at the meeting, but she just she has that tendency to internalize these things and assume that it's related to her. So her mother's decided, that it's okay to have her a little bit at the beginning, but after that, have her, return to the classroom. Okay, so the placement. So the placement is a decision that's made by the IEP team. This is the setting in which that student is required to learn, that the setting that the student needs to be able to make effective progress. The team can only consider the unique needs of the child, again, similar to services. They can't consider the cost of the placements or what slots are available. Excuse me. The law prefers inclusion with non-disabled students as much as possible, and this is regardless of grade level, whether that student is at grade level. So if the school district is only using certain assessments to make a determination that the student should be in a substantially separate setting, but there are certain aids and supports that can be provided to that student so that they can make progress in the general education setting with non-disabled peers, then the law prefers that. And there are many placement types, from full inclusion, which is the least restrictive, to residential, which is the most restrictive. And this slide just lists out the different settings for 6 to 21-year-olds for placements. And there's a separate placement consent form that parents are asked to sign in addition to the IEP. Okay, so the parent has gone through the whole process, the evaluations, the team meetings, and they've received the IEP in English and in their primary language if they need it in a language other than English. And they have 3 options here. They can fully accept the IEP. So by doing so, they're saying that they're in agreement with all of the services, all the goals, and everything that's in the IEP, including the amount of the services and who's providing the services. Their parent concerns have been nicely outlined at the beginning, and they agree with everything. So they accept the IEP as developed. Full rejection, often parents that are frustrated with the process, because they don't have enough understanding of how to understand the IEP and how to respond to it, will fully reject the IEP because they just don't trust. They don't trust the IEP. They don't trust the school district. And by doing that, they're saying that they don't agree with anything that's in the IEP. But in terms of the effect of the full rejection, the school district is required to continue implementing the most recent accepted IEP. So unless it's the student's first IEP, the services from the most recent accepted IEP will continue if the parent fully rejects the IEP. So the recommended, generally, in most cases, option here in responding to the IEP is to partially reject the IEP, which is the third box there, the second one on the left, and to list the reasons why they're rejecting the IEP in part. It could be that the parent doesn't agree with the speech services, that the amount of speech services that are in the IEP, or the fact that there are not speech services in the IEP, to give an example. They may be rejecting that the goals haven't changed in 2 years. That's a red flag. If the student has the same goals for 2 or 3 years in a row, then the parent can note that in partially rejecting the IEP. This is just a clip from another one of the videos that will be circulating about responding to the IEP. Oops. Oh, here we go. So in the example where the school district and the new IEP, so the parent has compared the two service delivery pages, one from the current IEP and also the service delivery from the IEP that's being proposed. And they see that the school district has eliminated services from the IEP. This highlights a really powerful right that parents have in special education. If they partially reject the IEP and state that they're rejecting the elimination of that service, then the services must continue until the parent gives consent by signing the IEP, or until the school district takes the matter to hearing and a hearing officer decides that the student no longer needs those services. Those are referred to as stay put rights. The same applies in terms of the placement. So if a student is in inclusion and the school district is proposing to put that student in a substantially separate classroom, the parent doesn't agree, and the student, if the student is old enough, doesn't agree with that, and if the parent rejects the change in placement, then they have stay put rights, and the school district must continue providing services in general education. Just to provide a couple of examples, I always recommend that the parent go ahead and arrange for an independent expert evaluation if there's this type of disagreement, because there's always the chance that it could go to a hearing, and then the determination at that hearing will often depend on on the evaluations. So while they're doing this and while they're maintaining the services or the placement that their child is receiving, they should also make those arrangements to get a second opinion or an independent expert evaluation. And if you contact our helpline, we have sample partial rejection letters, or in some cases, we're able to review the proposed IEP and the prior IEP for the parent to make suggestions, especially where they have an independent evaluation, which actually brings me to the next one. Oftentimes, the parent will have it. They'll have an independent evaluation with some great recommendations, hopefully very specific for the team to consider. And they have presented that to the team, and none of it is reflected in the IEP, or there are key components of the recommendations that are not reflected in the IEP. The parent has the option to, again, partially reject the IEP. So they agree that their child should be eligible for special education and to receive some of the services that are included in the IEP, but they disagree with the omission of certain services or accommodations if those aren't listed in the IEP. And they can reference that independent evaluation again in their response, and what recommendations from that evaluation they're requesting that the school add to the IEP. And then they can request another meeting, and then they can discuss that. Oftentimes, depending on the type of evaluation and the recommendations, sometimes it requires more than one independent evaluation. So if the student has had, let's say, an independent neuropsych evaluation that's more general, maybe it's recommending increased ABA services. It may be necessary for the parent to also get an independent evaluation from an ABA provider to make a more specific recommendation regarding the amount of ABA, hopefully to go to the school and do an observation just to assess the quality of the ABA therapy that's being provided in that setting, just to provide that example. So those are, in making the response for the omission of services, sometimes that will be necessary. And if you have questions or the parent has questions, you're welcome to contact Mac's helpline, and we can talk through the specific scenario. So I'll stop here for questions again.
Okay, thank you for your questions. Again, those can be submitted to the question box at any time, and we'll be reading them during our question breaks. Also, you'll have an exclusive first look at some of these videos. We'll be sending those out after the webinar. Okay, so our first question is, are there a required number of days from the day of the IEP meeting that the English and translated copy of the IEP are required to be sent to the parent?
So yes, the school district is required to provide the proposed IEP in English and, if necessary, a translated copy within 45 school working days of the parent giving consent for the evaluation. So that's the time frame. And parents, I often tell parents, there's so much pressure often placed on parents to sign the IEP, within the 30 days. They often list a date, 30 days from when they give the IEP. And if it hasn't been given in the parent's primary language, which it should be, as I mentioned before, there's nothing in the law that provides additional time for school districts to provide a translated version of the IEP. So there's no additional time allowed. So they should be given at the same time in English and in Spanish within the 45 days or whatever other language it is. And if they aren't, the parent, should absolutely not feel pressure to sign the IEP. They should not sign the IEP in a language that they don't understand. If this is an issue, you can contact the helpline, or the parent can contact our helpline. Often it's just a call to the school district if they haven't received it in English or the other language. For them, just a call from an advocacy organization can really make a difference there. But I'll often note when it's a client of mine and they haven't received it in my clients are Spanish speaking. If they haven't received it in both languages, I note that in the response to the IEP. I ask the parent what they want me to do here. If they want my assistance in responding to the IEP, I'll review it with them in English. It always depends on the circumstances in the case, what they want to do, and then document in the response why it was late. Either that it wasn't provided if the parent has requested that I respond to the IEP, or if the parent is delayed in responding, in the response just note, that they received the translation on this much later date, which is why their response is late.
Okay, and just one more question. Can parents submit their complaints or their disagreements with the IEP in Spanish, or I guess any language other than English?
So, yes. And these are complaints that they're making to the school district. You can, if they're directly to the school district. I'm not sure if that's the type of complaint that you were referring to. But the school district should be able to translate anything that the parent provides to them in writing, or to provide an interpreter when a parent has a complaint. Also, complaints to the problem resolution system. And in the slides, the link is there. The form is available in many languages. and the parent can absolutely complete the form in a language other than English and submit it, and they are required to review it and respond.
Okay, thank you everyone for your questions. We're going to be moving on. Please submit your questions at any time. I'll be reading them at our next break.
Okay, and submit them fast because we're almost at the end. So these are options if the parent has gone through the special education process and they've had that, they've gotten the independent evaluation. The team has, they're required to consider the independent evaluation. So they've had a team meeting to talk about the independent evaluation, and the parent still disagrees with the IEP that the school district is proposing. Then parents have some options. They can request a mediation through the Bureau of Special Education Appeals. And with this option, the school district also has to be mutually agreeable. So, to proceed with mediation, but that is an option. The parent can request a hearing through the Bureau of Special Education Appeals, and often this requires the assistance of an experienced advocate or attorney to file a hearing request. And I know, at MAC, it's when we are able to do this, we require, that the evidence kind of needs to be lined up. So the independent evaluations, observations, kind of need to be in place. But we often make referrals if the parent is seeing that they need to pursue a hearing with the BSEA. If the parent feels like the school district is not following the law, maybe they're not providing a service in the IEP, maybe the parent has heard that the occupational therapist is on leave and that they haven't replaced the occupational therapist, and they've addressed this with the school, and the student still isn't receiving this service, so they're not following the IEP, it would be appropriate to file a complaint with the Problem Resolution System, or PRS, and the link again is here. Similarly, if they're not, if they're violating the parent's rights to language access, the interpreter that they've provided at the team meeting is not qualified. Maybe they, actually a colleague was just describing a situation where she was at a team meeting and the interpreter, made a joke about, that she was just going to paraphrase because it would take, 3 hours to get through the meeting if she interpreted everything. A case like that, if it's really not a qualified interpreter, or the interpretation is not being carried out appropriately, that would be a basis for filing a complaint, of course, with PRS. Again, if you're thinking about doing this, I would just suggest contacting our helpline, and we can just give some tips on how to do it, because the department sometimes they need it kind of laid out in a in a certain way, really, to be able to see the issue compared with whatever the school district is going to however the school district is going to respond, because the school district, of course, does have the opportunity to respond. Another point, PRS, it's only in writing. So parents sometimes, they're actually pretty accessible by phone, which is nice. So parents can call and advocates can call PRS when they have questions, but sometimes parents think that they're making a complaint when they're talking to them over the phone, and that's not the case. It's a paper complaint process, so they need to submit a paper complaint. And then finally, the U.S. Department of Education Office of Civil Rights is if the parent feels like the school district is discriminating against their child on the basis of national origin or their disability or any other protected class or race, then they can file a complaint with the U.S. Office of Civil Rights. Again, contact MAC. If you're thinking about doing this, it's a kind of formal complaint process. It's also a federal government agency, so there may be drawbacks to filing a complaint with the OCR. So talk to us. We can often reach out to people there to get a sense, and reach out to our colleagues, our collaborators in the community to kind of gauge whether that's the best route to take. And of course, so again, contact the MAC helpline for help with any of these options. Here are some takeaway points. So all of the rights discussed in this webinar apply regardless of the parent or student national origin or immigration status. So all of the rights related to special education and access to a public education. Children receive better services when parents are involved. And of course, I'm sure many of you have seen that limited English proficient and immigrant parents just have more barriers to participating in the process. So it's important. So it just requires more of them to participate, and including more support from people like you and other advocates in the community. Interpretation and translation is required by law and essential for many parents to participate. Evaluations must be conducted in the student's native language if necessary. The IEP must address the language needs of limited English proficient students with disabilities, and students cannot eliminate services from the IEP without parent consent or a decision from a hearing officer to do so. So I thank you all. Oh, and then we just have some additional statewide advocacy resources here, which are primarily for low-income families. Although MAC's helpline, they're not exclusively for low-income families. For example, I know MAC's helpline is available to parents regardless of income, and some immigration-related resources. So thank you all. I think there is one more question, so we'll go with that.
All right, we're just going to squeeze in one last question here. If a parent has not gotten proper treatment around interpreters, information in their language, or other problems related to limited English proficiency, is there a section of the law that they can mention to the school to show that they know about their rights?
Yes, there is a section of the law. There's actually a nice, a couple of years ago, are we circulating anything after the webinar? Could we include something? Yeah, we could include this. It's a handout. It's like a 2-page summary of some guidance that was issued by the Federal Department of Justice and Department of Education related to requirements, language access requirements for LEP students, and there's one for LEP parents also to participate in school. So it's kind of a handy thing with an official letterhead and everything from the government. And then there's also, in terms of state Massachusetts special education law, which is it's 603 CMR 28.00. I don't remember the exact number that addresses language access, but it's the parent participation section of that law. So if you contact me after the webinar, I can send you the exact site, but there are it's explicitly addressed in Mass special education law also. Okay, so thank you everybody for all of the work that you're doing with Immigrant. and limited English proficient families. I hope that you found the webinar to be helpful. Please complete the participant survey that you will receive very soon after the webinar. And feel free to contact Max Helpline in the future if you have any specific questions. Okay, thank you.